Hello everyone. Today we will be discussing some multiple choice questions on intellectual property rights, that is IPR. In this video we will take up our last topic of intellectual property rights, which is copyrights. So without wasting much time, let's start our video. Question number 1. What protects the intellectual property created by artists? Option A. Copyright. Option B. Geographical indications. Option C. Patents. Or option D. Registered designs. The correct answer for this question is option A. Copyright. Question number 2. Copyright means option A. Right to copy. Option B. Right to adapt. Option C. Right to reproduce. Or option D. All of the above. The correct answer for this question is option D, all of the above. Question number 3. Copyright protects option A, idea per se, option B, expression, option C, both option A and option B, or option D, none of the above. The correct answer for this question is option B, expression. Question number 4. Copyright is a option A. Negative right. Option B. Positive right. Option C. Bundle of exclusive rights. Or option D. Both option A and option C. The correct answer for this question is option D. Both option A, a negative right, and option C, bundle of exclusive rights. Question number 5. In India, copyright is a option A, statutory right, option B, private right, option C, common law right, or option D, all of the above. The correct answer for this question is option A, statutory right. Question number 6. Copyright Act was enacted in which year? Option A, 1999. Option B, 1914. Option C, 1957. Or option D, 1970. The correct answer for this question is option C, 1957. Question number 7. Copyright protection is available for option A, expression, option B, original expression, option C, original idea, or option D, all of the above. The correct answer for this question is option B, original expression. Question number 8. In which of the following copyright does not subsist? Option A, industrial designs. Option B, artistic works. Option C, computer software. Or option D, sound recording. The correct answer for this question is option A, industrial designs. Question number 9. Copyright protection is available for option A, published work. Option B, unpublished work. Option C, both option A and option B. Or option D, none of the above. The correct answer for this question is option C, both option A, published work, and option B, unpublished work. Question number 10. According to section 13 of the Act, copyright subsists in option A, dramatic and musical works. Option B, cinematograph films. Option C, brand name. Or option D, both option A and option B. The correct answer for this question is option D, both option A, dramatic and musical works, and option B, cinematograph films. Section 13 of the Copyrights Act 1957 provides the classes of works in which copyright shall subsist throughout India. These are: number 1, original literary, dramatic, musical and artistic works; number 2, cinematograph films; number 3, sound recording. But copyright shall not subsist in any cinematograph film if a substantial part of the film is an infringement of the copyright in any other work, and in any sound recording made in respect of a literary, dramatic, or musical work if in making the sound recording copyright in such work has been infringed. Question number 11. Software comes under option A, artistic work; option B, literary work; option C, cinematographic film; or option D, all of the above. The correct answer for this question is option B, literary work. Question number 12. In India, song can be considered as option A, literary work; option B, musical work; option C, artistic work; or option D, both option A and option B. The correct answer for this question is option D, both option A, literary work, and option B, musical work. Question number 13. Artistic work for the purpose of copyright does not include which of the following? Option A, an idea of a painting; option B, a map; option C, a sculpture; or option D, a photograph. The correct answer for this question is option A, an idea of a painting. According to Section 2, Clause C of the Copyrights Act 1957, artistic work means: number 1, a painting, a sculpture, a drawing, including a diagram, map, chart or plan, an engraving or a photograph, whether or not any such work possesses artistic quality; number 2, a work of architecture; number 3, any other work of artistic craftsmanship. Question number 14. Generally in copyright law, who is the first owner of copyright? Option A, employer; option B, author; option C, assignee; or option D, applicant. The correct answer for this question is option B, author. Question number 15. As per Copyright Act 1957, author in relation to a photograph means: option A, the person taking the photograph; option B, the person commissioning the photograph; option C, both option A and option B; or option D, none of the above. The correct answer for this question is option A, the person taking the photograph. According to Section 2, Clause D of the Copyrights Act 1957, author means: in relation to literary or dramatic work, the author of the work; in relation to musical work, the composer; in relation to an artistic work other than photograph, the artist; in relation to a photograph, the person taking the photograph; in relation to a cinematograph film or sound recording, the producer; in relation to any literary, dramatic, musical, or artistic work which is computer generated, the person who causes the work to be created. Question number 16. Cases where the author is not the first owner of copyright. Option A, work made in the course of employment; option B, work made under the contract of service; option C, work made under the contract for services; or option D, both option A and option B. The correct answer for this question is option D, both option A, work made in the course of employment, and option B, work made under the contract of service. Question number 17. During the course of employment for Shivas Limited, Rajiv created a literary work. Who is the owner of the copyright in the work? Option A, Shivas Limited. Option B, Rajiv. Option C, both Shivas Limited and Rajiv. Or option D, none of the above. The correct answer for this question is option A, Shivas Limited. Question number 18. Copyright includes option A, economic rights, option B, moral rights, option C, both option A and option B, or option D, none of the above. The correct answer for this question is option C, both option A, economic rights, and option B, moral rights. Question number 19. What are the exclusive rights given to the owner of copyright in relation to a literary, dramatic, or musical work? Option A, to reproduce the work. Option B, to perform the work in public. Option C, to make any cinematograph film or sound recording in respect of the work. Or option D, all of the above. The correct answer for this question is option D, all of the above. Question number 20. Exclusive rights that are not given to the owner of copyright in relation to artistic work. Option A, to communicate the work to public. Option B, to make an adaptation. Option C, to sell or give work for commercial rental. Or option D, to reproduce the work. The correct answer for this question is option C, to sell or give work for commercial rental. Question number 21. Right to sell or rental is restricted to option A, sound recording, option B, cinematograph films, option C, computer program, or option D, all of the above. The correct answer for this question is option D, all of the above. Question number 22. Copyright in any design which is capable of being registered under the Designs Act 2000 but has not been registered shall cease as soon as any article to which such design has been applied to is produced. Option A, 50 times or more. Option B, less than 50 times. Option C, less than 40 times. Or option D, none of the above. The correct answer for this question is option A, 50 times or more. Question number 23. Moral rights recognized for the authors are option A, right of paternity. Option B, right of integrity. Option C, both option A and option B. Or option D, none of the above. The correct answer for this question is option C, both option A, right of paternity, and option B, right of integrity. Right of paternity. Right of paternity means that an author has a right to claim authorship of his work and can prevent all others from claiming authorship of his work. The author also has a right to demand that his name should appear in all copies of his work at the appropriate place. He can also prevent others from using his name in their works. Right of integrity. Right of integrity means that an author has a right to prevent distortion, mutilation, or other alteration of his work or any other action in relation to the said work which would be prejudicial to his honor or reputation. This right is important particularly where a license or assignment has been granted to adapt or alter the work in some way. Question number 24. Which section of the Copyright Act 1957 recognizes the moral rights of authors? Option A, Section 50. Option B, Section 55. Option C, Section 57. Or option D, Section 65. The correct answer for this question is option C, section 57. Question number 25. The first dispute in respect of author's moral rights is option A, Amarnath Sehgal versus Union of India. Option B, Manu Bhandari versus Kala Vikas Pictures Limited. Option C, S. Mahalingam versus Vasan Publications Private Limited. Or option D, none of the above. The correct answer for this question is option B, Manu Bhandari versus Kala Vikas Pictures Limited. That's all for today. I hope you all learned something new. In our next video, we'll take up some more questions on copyrights. Keep learning. All the best.